In multinational families, a single death can trigger probate proceedings in several countries at once. Assets may be located in Vietnam, Singapore, Australia, the United States, or Europe. Each jurisdiction operates independently. There is no global probate court. Multi-jurisdiction probate refers to administering an estate across more than one legal system. Each country applies its own inheritance law, procedural rules, and recognition standards. Coordination is not automatic. Effective management begins with a full inventory of assets. Immovable property in Vietnam, foreign real estate, bank accounts in different jurisdictions, corporate shares held domestically and abroad. Asset location defines the legal pathway. For real estate located in Vietnam, Vietnamese law generally governs succession. Foreign probate decisions alone cannot transfer land use rights. Domestic procedures must be completed. Similarly, assets located outside Vietnam are governed by the law of their respective jurisdictions. Vietnamese inheritance determinations cannot compel foreign land registries or banks. Parallel administration is often required. If probate has already been granted abroad, recognition by a Vietnamese court may be required under Vietnamese procedural law before domestic transfer or enforcement can proceed. Legalization, certified translation, and judicial review form part of this process. Recognition is a separate legal stage. It is not unusual for probate to proceed simultaneously in Vietnam and abroad. This creates risk of inconsistent interpretations. Coordinated legal strategy reduces duplication and contradiction. In a multi-jurisdiction estate, different parts of the estate may be governed by different laws. Vietnamese inheritance law may apply to local real estate. Foreign law may govern overseas property. Clarity requires structured analysis. Vietnamese forced heirship rules may affect assets located in Vietnam. Foreign jurisdictions may have different approaches to compulsory shares. Different legal systems may provide different levels of compulsory protection, and heirs may rely on the governing law most favorable to their position. Multi-jurisdiction probate often triggers tax reporting in more than one country. Inheritance or estate tax obligations abroad may coexist with Vietnamese reporting requirements. Failure to coordinate creates financial exposure. Documents issued in one country typically require legalization before use in another. Vietnamese authorities require properly authenticated foreign probate judgments and death certificates. Procedural defects cause delay. Banks in different jurisdictions operate under local compliance rules. Release of funds depends on domestic probate or recognized foreign orders. Liquidity planning is critical in cross-border estates. If the deceased held shares in Vietnamese and foreign companies, each corporate registry applies its own succession rules. Voting rights and governance may remain in suspension during probate. Business continuity must be managed proactively. In multinational estates, heirs may reside in different jurisdictions with different legal advice. Competing interpretations of governing law can escalate into litigation. Unified strategic direction is essential. Separate wills tailored to each jurisdiction can simplify administration. Each document addresses assets within its respective legal system. Coordination prevents unintended revocation. Multi-jurisdiction probate typically takes longer than single-jurisdiction estates. Procedural sequencing must be planned carefully. Delay in one jurisdiction can stall transactions in another. A court judgment in one country does not automatically enforce in another. Recognition procedures may be required. Judicial sovereignty remains decisive. Appointing coordinated legal advisors across jurisdictions reduces fragmentation. Information consistency prevents contradictory filings. Structure improves predictability. If your estate spans Vietnam and other countries, probate should be treated as a coordinated project, not a series of isolated proceedings. Mapping jurisdiction, governing law, and procedural requirements in advance reduces post-death disruption. Multi-jurisdiction probate is not inherently unmanageable, but it requires deliberate coordination between Vietnamese law and foreign legal systems. Assets follow jurisdictional boundaries, structure must anticipate them. Without coordination, parallel systems create parallel problems. If your estate spans Vietnam and multiple foreign jurisdictions, probate should be approached as a coordinated legal strategy, not isolated local procedures. Recognition, governing law, tax exposure, and enforcement must be aligned across systems. To structure a disciplined multi-jurisdiction probate framework tailored to your assets, contact LTS Law at lts.com.vn for cross-border legal guidance. In multinational estates, coordination is not administrative, it is strategic control.